Hi, good afternoon. My name is Ana Lopez. I'm an attorney. I'm licensed in New York. I practice immigration, probate, estate planning, and family law. But today we're going to talk about family-based immigration. And so we're going to be talking about what it means when we talk about family-based immigration. Okay. So if we can go on to the next slide, we can get started. So here are the things that we're going to cover as we get into our topic today. We're going to cover what are immigration laws, what is immigration, like who is an immigrant and what different types of immigrants there are. Then we're going to talk, the major portion of our conversation is going to be based on family-based immigration. We're going to talk a little bit about waiting times, and then I'll let you know how you can contact me. And so we can begin with the next slide. So what is immigration laws and how are immigration laws governed? In the US, immigration laws govern who can come into the US, how long they can stay in the US, and what benefits they have access to. So what that means is that immigration talks about, when you want to travel to the US, like who can come in, because you can get a visa, but you may not necessarily be admissible to the US. So that's what who can come means. It's admissibility, whether or not you qualify to be admitted into the US. How long they can stay depends on what kind of visa you have or what kind of immigrant you come in as. Are you coming in as a tourist immigrant? Are you coming in as a employee immigrant, meaning that you're being sponsored by a company or by someone to come and work for them in the US? Are you coming in as a family member of a US citizen? Are you coming in as a family member of a lawful permanent resident? And so that will determine how long you can stay. And then the benefits include, like, for example, if you're here and something happens, depending on what kind of immigrant you are you able to access emergency Medicaid? Are you able to access certain health, benefits? Can you ask the government for assistance in, certain things? And so those are what benefits refer to, like what can the government provide for you, or what help can you get, whether it's from the public sector or from the government as an immigrant here in the US while you're here. And then if we can move on to the next slide. Now we're going to talk about what the immigration spectrum is. So immigration covers people who are here undocumented. It covers people who come here seeking asylum. It covers people who have a visa of some kind, whether it's a tourist visa or any other kind of visa. It covers lawful permanent residents, so the people who may hold citizenship in another country but are lawfully permanently residing here in the United States. It covers people who have DACA, who are, now they're adults, but they're people who were brought here as minors without fault of their own, who have been given a work permit and temporary protection from deportation, so long as they meet all the DACA requirements and are renewing their DACA every 2 years. It covers employment visas. It covers families that have mixed status. What does that mean? That there's some families that maybe, some people are US citizens, whether they have been naturalized or because they were born here. It also covers people who maybe have a mix of that and people who are undocumented, or maybe they have, a family member who has DACA and then others who are permanent residents. Mixed family status. Covers a little bit of everything. And then the last thing is people who are formally undocumented. What does that mean? Someone who has adjusted status, whether they've adjusted through, a family member, through employment, or, any other avenue through which they have adjusted. They are no longer undocumented, but are now either holders of a permanent residency card and or have, already been permanent residents and have applied for citizenship. Okay, so that's what the immigration spectrum is. As you can see, it covers a variety of people and many, many different things. So then now we're going to move on to the next slide. And we're going to talk about family-based immigration. So one of the things that, I want to say is that when people think family-based immigration, they don't really think about family-based. They're usually thinking about, what they call chain migration. So what is chain migration? Well, first of all, it's a term that does not exist. Why do I say that? Because chain migration is not real. What is real is family-based immigration. There is a misconception in our society because of social media, because of certain news outlets, because of certain misinformation, that when we talk about family-based migration, you're referring to chain migration. Chain migration, as I stated previously, is not real. It's not like if you're a U.S. citizen, for example, you can petition your cousin 3 times removed, from your mother's side or, your father's side. No, family-based immigration talks about the nuclear family. So typically, the only people you can request are members of your immediate family. What does that mean? You can request your parents, you can request a son or a daughter or a spouse and a sibling. But you cannot petition your grandmother. You cannot petition your grandmother's sister. You cannot petition your aunt or your cousin or a great grandparent or a great nephew, niece, whatever. So when we talk about family-based migration, we're talking about one person who is the nucleus, who's either a permanent resident or a U.S. citizen, petitioning a parent, a spouse, a child, or a sibling. And that's what we mean by family-based immigration. And now we go back to the presentation, we're going to see what I was talking about. U.S. citizens can petition immediate relatives. For immediate relatives, visas are immediately available. And so what an immediate relative refers to, as you can see, is a spouse, an unmarried child under 21, and a parent of an adult U.S. citizen. Family sponsor preferences, as you can see, must all wait for a visa. So what does that mean? That means that if you have a child who is unmarried but is maybe above the age of 21, if you have a sibling who is not a U.S. citizen, who is a citizen of another country, and or a married son or daughter that is not in the United States, you can still petition them, but they're going to fall under family-sponsored preferences. And so that means they're going to fall under a different preference than an immediate relative, and they will have to wait until a visa becomes available. And so one of the most common questions I get is that, why do they have to wait for a visa if I'm petitioning them? Well, because to come into the U.S., you have to have a visa. There are different types of visa. A visa does not necessarily mean a tourist visa, but to come into the United States, you have to be vetted by the State Department. They have to say, okay, you can come into the U.S., here's your visa, and then, you present that visa to the immigration officer. They open the visa and they say, okay, everything looks good, they do their thing, and then you can come in. So that's why they must wait for a visa, because they still have to have a way, an avenue to be admitted back, to be admitted or admitted back if they have been deported previously or have lived here previously into the U.S. We have a question. And so Annette, I'm not entirely sure, said, they're talking about a family petition to say, there's a husband of a U.S. citizen. My case was sent February 20th. It was accepted. Why is it taking so long? And it's a consular processing. Okay. So one, I'm not entirely sure what your case is about, but why is it taking so long? Because of COVID. Right now things are behind. And so I know you're probably getting tired of hearing COVID, but that's one of the main reasons why petitions are being processed at a later time, because not every embassy or consulate has been open throughout the whole pandemic. One of the reasons why it's taking so long is also probably because it's a consular process, which means that perhaps, and like I said, I don't know the specifics of your case, but it is possible that, perhaps you are waiting for a waiver. And so that's probably why you're waiting so long. Since it is a Spanish question, I'll go ahead and translate what I just said. Me pregunta que ella o alguien hizo una petición familiar para un esposo de ciudadana americana. El caso se envió en febrero, que ya fue aceptado, ya todo fue aceptado, pero ¿por qué se están tardando tanto en dar entrevistas? Ya que su trámite es un trámite consular. Una de las razones por las cuales se está tardando tanto es por COVID. Yo sé que la gente ya se está cansando de escuchar que estamos en pandemia y que por eso las cosas se están alargando, pero hay que recordar que no todas las embajadas ni todos los consulados en otros países están al día. Como por ejemplo en Ecuador, yo sé que en Quito, la embajada en Quito está atrasada más o menos, si me acuerdo bien, como 9 meses. Entonces, aunque hay casos que ya fueron aprobados, las entrevistas quizá no se den hasta el próximo año. ¿Por qué? Porque la embajada en Quito, Ecuador, cerró durante la pandemia y apenas han reabierto no hace mucho. Entonces, es quizá por eso que su caso se está alargando, porque a lo mejor la embajada o el consulado en México no estuvo abierto al 100% durante la pandemia y por eso se está atrasando. También su proceso es un proceso consular. Los procesos consulares son más largos. Y si usted está esperando un perdón o su esposo está esperando un perdón, eso también puede atrasar el proceso. And then we have another question that says, I'm a permanent resident. What family members can I petition to live in the U.S.? Well, I'm glad you asked because we're about to get into that. So back into the presentation. Now we're going to talk about lawful permanent residents. What's a lawful permanent resident? As I've stated before, a lawful permanent resident is someone who has citizenship in another country but has, immigrated to the U.S. and are here lawfully, meaning they can live here, they can work here, and they have chosen the U.S. as their permanent place of residence. So who can they sponsor? Permanent residents can sponsor a spouse and unmarried children under 21. They can also sponsor unmarried children over 21. But, as I stated, as you can see, this is family-based immigration. It's very immediate. So a U.S. citizen is going to have more people they can sponsor, but also it has to be people within their nuclear family, whereas a permanent resident can only sponsor or petition a spouse and children. So that's the answer to your question. Who can you petition? Your spouse and your children. We have another question. It says, my sister, who is a United States citizen, applied for me in 2014. I'm an F4 category. I am from India. How long do I have to wait for GCC? I'm in the U.S. now on an H-1B. Any way we can adjust or get it expedited? That's a very specific question that I cannot answer because it, will bring in a little bit of ethics and legal advice, and I'm not giving legal advice. This is just an educational presentation. And so you can always contact me on Kounsel and we can go over your very specific case, and I'd be happy to help you that way. But that's not a question that I'm going to be able to answer here. Specifically, what I can say is that based on your category, it depends on how many visas are available and where they are on the visa bulletin. So that's all I can say on that matter. And so then now we can move on to the next slide, which is the waiting times. Everybody wants to know, what are the waiting times? How long do I have to wait? And so I want to remind everybody that these are just general waiting times. They're guideline waiting times. That doesn't mean that if, for example, you're married to a U.S. citizen, they petition you tomorrow, you're a spouse, it gets approved, you're going to have to only wait X amount of time. These are just guideline times. things are behind. And you have to remember, we're also in the middle of a pandemic. If we were already behind pre-pandemic, with the pandemic, we're even more behind. Or we're not, the government is more behind. So these are just guidelines. They're estimated times, but it can be longer. There's no set time that an attorney can give you to say, oh, you're gonna be able to adjust by this date. If somebody does that, it's not good. I'm not saying they're lying to you, but you might want to consider, who are you speaking to, and are they really a licensed attorney? Because no licensed attorney will guarantee you a certain date by the time you will be able to have your visa or your residency or whatever it is that you're seeking as a benefit from immigration. So, okay. So a spouse of a U.S. citizen, from start to finish, typically takes from 10 to 17 months to obtain a green card. It's an average, is an estimated time, but it can take longer. It just depends on, again, where you are in your process, where is the person located, and, what the waiting times are in that specific country, whether that embassy is caught up, are they not, but typically, because it is an immediate relative, a visa should be made available immediately. And immediately does not mean in an instant, but it does mean as soon as possible. Okay, and so that's an average of 10 to 17 months. Getting back into the presentation, spouses of U.S. citizens living in the United States can file to adjust with the 130 and the 1485 at the same time. And typically, if you're in the U.S., it's going to take 10 to 13 months. Typically, it's an average, not an exact number. And if you're going to marry a U.S. citizen, but you live outside the United States, it takes typically 11 to 17 months to get a green card based on marriage. Again, these are estimates. They're not exact time frames that can be used to sort of see where you're at. Again, it's going to depend a lot on where you're at, whether you're in the U.S., whether you're outside the U.S., where you're from, whether you're doing a consular processing, whether you are not doing a consular processing because you were previously admitted to the U.S., on a visa and you overstayed, or whether you were admitted on a K-1 visa, which is a fiance or fiancé visa. It depends, but those are typically what the waiting times are. Now, for spouses of green card holders or lawful permanent residents, from start to finish, the time is longer. It's typically anywhere from 23 to 38 months, and that's how long you will have to wait before you're able to get a green card that becomes available to you once your spouse files the I-130, which is the petition based on the family status, right? And so, again, in most cases, it's going to take about 2 years for the visa to become available. And the entire process, meaning the petition to the time you actually receive the green card and everything has been concluded, and you no longer have to worry about going in for biometrics or interviews or whatever, is going to be about 3 years. Again, it's also constantly changing because of the pandemic. And again, it's going to depend on where you're at, where you're from, and how long that country or the embassy in that country has its own waiting times. But typically, it's about 3 years. So there are, for permanent residents, countries that take longer. For example, Mexico, China, India, and the Philippines, that's going to take longer than 3 years. Why? Because there's so many petitions, there's so many applicants from those countries that, those countries are already overwhelmed with the amount of petitions. So it's going to take a little bit longer if you're going to adjust through a permanent resident who is from those countries, or if you are from those countries. Because sometimes you might marry a person of the same country, I don't know. You don't know. Everybody's case is different. So if your spouse is a permanent resident and you currently live in the U.S., then you'll wait about 29 to 38 months, so even longer, to receive your green card. And if your spouse is a lawful permanent resident or a green card holder and you live outside the United States, you're going to wait about 23 to 32 months, give or take, before you receive your green card. So as you can see, it depends on who your petitioner is. The waiting times for a family member, or in this case, a spouse of a U.S. citizen, are going to be shorter, but it's not, and it depends whether you're in the U.S., outside the U.S., and where you're from. But it depends. Okay, and then the next slide, as you can see, we're going to be talking about widows and parents of U.S. citizens. If you're a widow of a U.S. citizen and you're adjusting as a widow of a U.S. citizen, from start to finish, your timeline is looking anywhere from 10 to 13 months. The application is very similar to a marriage-based green card process, but it's a different form and it's a different process. Similar but different. And so this wait time is anywhere from 10 to 13 months. But again, it's going to depend on where you are in the process and, how, when, where you apply. Okay. And a parent of a U.S. citizen, likewise, is also going to take anywhere from 10 to 13 months. Like spouses of U.S. citizens, parents of U.S. citizens should have a visa made available immediately because there's no limit, there's no cap. And so typically, most parents of U.S. citizens can usually get a green card within a year of applying for a family-based petition. But then again, it can change. It can vary depending on how complicated the process is, whether your parent has had a previous deportation order, a voluntary departure, whether they've ever been to the U.S. or not, whether they're here. It's going to depend a lot on what the specific circumstances of your cases are. However, typically, for the most part, it's only going to take about a year. Okay. The next slide, now we're going to talk about children. We're going to talk about minors specifically. And so we're going to talk about minors, meaning children under the age of 21. From start to finish, if you're a child of a U.S. citizen under the age of 21, it's going to be 10 to 13 months. There's no limit on the visas or the green cards available to minor children of U.S. citizens, so they should be made available immediately. And so typically for a child, especially if it's a minor, it's going to take a year or less. Okay, now for minor children of green card holders, meaning lawful permanent residents, start to finish, it's anywhere from 23 to 38 months. It's slightly longer. And minor children of green card holders do have to wait for a green card to become available after their parent files the petition and before they can apply for a green card, whether they're inside the United States or outside the United States. Minor children of green card holders fall into the same categories as spouses of green card holders, and so they have a typically shorter wait time than other categories of people who are waiting for visas. And so in most cases, a minor child of a green card holder is going to take about 2 years. One of the questions that I think I saw was whether or not there's a way to expedite a case. Certain circumstances can allow for a request to expedite a case. However, those circumstances have to be very, very I'm sorry, I lost the word I was looking for, but it has to be something that makes it imperative for that case to be expedited. For example, I had a case, a mother came to me, she said, hey, look, I filed to petition my child, the application was approved, and we did the consular processing, but we're still waiting for the appointment. However, my mom just recently passed away, and she was the legal guardian of my child. And now my child, she's still a minor. Yes, she's staying with my sister, but she can't stay there indefinitely. And so I was able to help her make a request to expedite the case, and the case was expedited. Why? Because the guardian of the minor child had died. So that means that now that child is basically alone in a different country, and that child needs to be reunited with the mother so that it's no longer a minor without a parent or without a legal guardian alone in another country. So that's one reason to expedite a case. Another question is, how long does it take? Diana asks, how long does it take to bring your parents to the U.S.? It depends on it's typically about a year, but it's going to depend a lot on what the circumstances of your parent are. And so, I already covered that, but, you can go back and check our PowerPoint later. I think it's going to be made available. Then another question is, what is the minimum income to sponsor a relative in Texas and New York in 2021? I don't have those available in front of me, so I don't know them off the top of my head, but they are, the USCIS provides guidelines as to what the poverty level is or what the minimum is. And I believe I did a sponsorship affidavit not that long ago, and I believe it was like $20,000 a year, but I don't remember the exact number. But whenever you're filling out the sponsorship affidavit, like, you'll be able to, if you're doing it on your own or you choose to hire an attorney, which is always the best thing to do, because they'll be more knowledgeable in filling it out and letting you know, like, hey, you might need a co-sponsor, or, whatever your situation is, they'll let you know whether or not you meet those qualifications. Okay, back into the presentation. Now we're going to talk about another category, which are unmarried children of U.S. citizens and green card holders who are over the age of 21, married children of U.S. citizens, and siblings of U.S. citizens. As you can see, unmarried children of U.S. citizens from start to finish, if they're over the age of 21, meaning they're no longer minors, the process is going to take 7 to 8 years typically. But as you can see, for children of U.S. citizens of very specific countries, such as the Philippines or Mexico, is going to take a lot longer. Why is the question I get asked all the time. It is because those countries are overwhelmed. They have way too many petitions, and so you have to wait until they catch up, so to speak. But as you can see, for the Philippines, it's at least 10 years. That doesn't mean it's going to take 10 years exactly. It means you're going to be waiting at least 10 years. It could be more. And for citizens of Mexico, it's going to be at least 20 years before you're able to bring your adult child into the U.S. And so that's why it's, something that you need to consider whether you want to do it or not. Of course you want to do it, but the wait time is going to be a lot longer. As for unmarried adult children of green card holders, again, the start to finish timeline for most countries is 8 to 9 years, but as you can see, for specific countries is going to be a lot longer. It's going to be the same for the Philippines and the same for Mexico. 10 years, at least 10 years for the Philippines, and at least 20 years for children of U.S. citizens who are living or are from Mexico. So yeah. And then for married children of U.S. citizens, as you can see, the time is even longer, which is 13 to 14 years. And another reason why, if you're married, it's going to take longer is because typically when you're petitioning a child who is married and you're a U.S. citizen, then you're also probably going to have derivatives, the spouse and any grandchildren. So it's more people that are being included within the same petition as a derivative, but also it's going to take just longer because it's not just one person and it's not a minor, and it's just a lot more stuff involved in that. And as you can see, for people, citizens of the Philippines and Mexico, it's going to be at least a 22-year wait. So typically, it shouldn't be 22 years, but for those two specific countries, it is going to be longer. And then the one that I get asked almost all the time is, hey, I'm a U.S. citizen. I have a sibling. They're not a U.S. citizen. I want to petition them. How long is it going to take? And that one is the one that is going to take the longest. And it's typically 14 to 16 years. But as you can see in our presentation, for citizens of certain countries is going to be a lot longer. For a sibling of a citizen of India is going to be at least 16 years before you're able to complete your process. For someone from Mexico, at least 20 years. From someone for the Philippines, you're looking at least 24 years. So what we're learning is that the further removed you are from the nucleus of the family, the longer it's going to take for your process to be concluded. And so those are the waiting times. And again, like I said, they're just estimated waiting times. There could be maybe certain things that could happen. I don't know, like maybe they choose to expedite your case. I've seen it happen where an application gets lost or it gets put on hold and they forget about it. And then as a way to make it up to you, they'll expedite it on its own motion. But that's very discretionary and doesn't happen very often. And all the time that I've been working for attorneys or have been an attorney myself, I've only seen it happen once. So, anything can happen, but these are typically the times that we're going to be looking at while you're waiting to be, for your process to be concluded. Okay. And then, that's all I have for you today in terms of our presentation. But I am open to taking questions. And so right now, if you have a question, it's a time to be asking. A question that it's being asked is, Joel is asking, can a U.S. citizen sponsor an immigrant? The answer is yes, and it depends. Who are you trying to sponsor? Are you talking about sponsoring in terms of a sponsorship affidavit? Yes, if you're a U.S. citizen, you can sponsor pretty much anybody. If you're talking about sponsoring in the sense of like you want to petition someone to help adjust status, then that means, it's going to be a very small group of people you can petition. If you're a U.S. citizen, you can petition your parents, you can petition your siblings, your spouse, and your children. And so those are the only people you can petition. But in terms of sponsoring, meaning signing an affidavit, the sponsorship affidavit that says, hey, this person is not going to become a public charge because I'm willing to, sponsor this person in that sense, then yes, you can sponsor pretty much anybody you want. Jose is asking, I am a permanent resident. Can I petition for my children? Yes, Jose, if you're a permanent resident, you can petition for your children. However, depending on where your children are, how old your children are, the times and the process is going to be different. So typically, a permanent resident can only petition minor children and unmarried adult children. Okay, so that's who you're going to be able to petition. If your child is married, you're not going to be able to petition him or her until you become a U.S. citizen. And back into children, like I said, we're going to go back to who can a lawful permanent resident sponsor or petition. It's going to be your spouse, unmarried children under the age of 21, and unmarried sons and daughters 21 and older. So I hope that answers your question, Jose. And if anybody else has more questions, I will be more than happy to answer them. I can see that Stephanie asked, can my husband petition my brother? The answer is no. Your husband cannot petition your brother. If you're a U.S. citizen, Stephanie, then you can petition your brother. But then again, depending on where they're from, it's going to take 14 to 16 years. Okay. So anybody has any more questions, please ask, because we have about 25 minutes left for me to answer questions, and I would like to answer as many questions as I can. And very briefly, I want to talk about a little bit about what's going on right now on in immigration. I know that I've been getting a lot of calls recently regarding the reconciliation bill and what the implications of the reconciliation bill are for immigrants. And a lot of people are like, oh, hey, can I just get, a green card or this and that. I want to clarify, the reconciliation bill, the portion that applies to immigration has only been passed by the House. It has not been passed by the Senate, which means that it has not been signed by the president and therefore is not law. And that can change because the version that's passed by the House is not necessarily the same version that's going to be passed by the Senate. And it is not a pathway to citizenship. It is not a pathway to residency. And we don't know exactly what the specifics of what that Plan C in the reconciliation bill is going to look like. Right now, it's based on what I have read and what I have researched. It looks a lot like DACA, just a very much more expanded version of DACA, but that doesn't mean that that's what the final version is going to look like. So, be very careful when you're doing your research or you're listening to certain people, because like I said, Plan C is not the law yet. And it's not something that you should be saving for right now. Stephanie is asking, so if I'm a U.S. citizen, can I petition anyone from my family? No, Stephanie, no. You can only petition immediate relatives, which means you can only petition your spouse, your children, your parents, and or a sibling, not just anybody from your family. And then Matt is asking, how can I do a more personal consultation? Matt, you can reach me through Kounsel, and the link is available in the comments, and I believe it's pinned in the comments, and that's how you can reach me. Matt está preguntando que cómo puede hacer una consulta más personal. Matt, me puedes contactar a través de Kounsel. El link está en los comentarios y creo que está pinned en los comentarios, y solo haces clic en mi link, haces una cita y así me puedes hacer una consulta más personal. Okay, Luis is asking, my wife was a U.S. citizen and passed away while sponsoring me. What can I expect now with the sponsorships still go on? Luis, I don't know where you are in your process, so I cannot really answer that question. Also, it's asking a little bit for legal advice, which I'm not going to do here. I'm only going to answer general questions. But Luis, you can contact me through Kounsel, and I can do a more personal consultation and see where your case is and what is going to happen. Typically, widows of U.S. citizens have about 2 years to do a petition as a widow, but it depends a lot on where you are in your process and whether what is happening. Has USCIS been notified of a spouse's death, things of that nature, which I cannot answer so publicly without getting in trouble. So if you want to do a consultation, please contact me through Kounsel, and I'll be happy to look at your case and give you options. Or if you already have an attorney, ask your attorney, what's the next step? but you can always contact me and I'll be happy to help you as much as I can. Back to what I was saying about Plan C is a lot of people are going to be eligible for Plan C, but again, there's going to be rules and specific requirements that we don't know what they are now. I can just say that it's very similar to DACA, but we don't know what those specific requirements and amounts and fees that are going to have to be paid are. So please don't think that it's the law yet. It's not. It might become the law or it might not become the law. I don't know. We don't know what the Senate's going to do. So just make sure that when you're looking into Plan C, you're looking at something that's either being put out by the White House, by Congress, or by a credible news station. Because I have been getting a lot of calls about that. People are like, oh, I want to, adjust status, or I want to get my papers through Plan C. And I'm like, Plan C, what are you talking about? Like, that's not the law yet. So be very careful about that. Okay. Any other questions? Anybody? One of the questions I get a lot is, about waivers. In Spanish, they're called perdones. What is a waiver? A waiver is basically a way to waive a situation that may make you inadmissible to the U.S. And, it's where you ask the government, like, hey, look, I know I was here illegally, but, please give me a waiver because of. And what is the because of? People think that the waivers is just like, oh, you're going to ask for something and it's going to be granted. But what you have to remember is that the waiver is going to be based on how the lack of your presence as an immigrant who is trying to stay in the U.S. or come into the U.S. is going to affect the U.S. citizen or the petitioner who is petitioning you, and typically is the U.S. citizen, right? So, for example, if the person who is petitioning you is a U.S. citizen, he or she has a serious medical condition, whether it be medical or mental health condition, that person would be terribly and extremely affected by the lack of your presence in the U.S., and it would inconvenience that U.S. citizen to a great degree to leave the U.S. and go with you to wherever you're from. Then, that would be a waiver that is appropriate, that might more likely than not be granted. But it's really going to depend on how the circumstances of your absence is going to affect the U.S. citizen. So an example I have is I have a client who is like, look, my spouse is HIV positive and, I want to apply for a waiver. And so the question here is, okay, your spouse who is a U.S. citizen who is HIV positive, are you that person's main caretaker? Yes. Okay. Could they receive treatment for HIV in your country in your country of origin without severe hardship? No. And so then, yes, that becomes a waiver that is going to be approved because that U.S. citizen would face extreme hardship with their medical condition in a foreign country, and they will not be able to sustain the same lifestyle that they would have in the U.S. in terms of medical and or possibly even social norms. So that's another waiver that can be done. I have another question before I continue on waivers. It says Kevin is asking, can I return to the U.S. as a green card holder if I have been outside the U.S. for 2 years? So, Kevin, that is a question that I'm not sure I'm understanding. However, if what you're saying is you were a permanent resident and you left the U.S. and you have been outside the U.S. for more than 2 years, the question, what I would say to you is to consult an attorney, and you can, like I said, you can contact me on Kounsel, and we can talk about your case more in depth. Why? Because one of the things that I think there's a misconception is that a permanent residence is for forever, or that there are no conditions on your permanent residence. I'm not saying no, but I'm also not going to say yes, because I don't know the specifics of your case, and I don't know what your specific situation is. But I will say this: when you're a permanent resident, you don't have a 100% I'm here, I'm allowed to be here forever kind of situation in the United States. You still have to be admissible back into the United States. And typically, green card holders or permanent resident holders can only spend a certain amount of time outside the United States, meaning they cannot be outside the United States for a prolonged period of time. That doesn't mean you can't go back and forth as much as you like. You can. However, because you're not a U.S. citizen, you're only a permanent resident. If you leave the U.S. as a green card holder and stay outside the U.S. for longer than you're supposed to, unless there's some kind of emergency situation that happened, and then again, like I said, it depends, then you are basically telling the government, hey, U.S. government, I know you gave me residency, but, I've chosen to stay in X place for X amount of time, which exceeds the amount of time that I'm typically supposed to be outside the U.S. And so therefore, I no longer want my residency. You're essentially giving it up. That doesn't mean that you won't be let back in, but it doesn't mean that you will either. Why? Because the immigration officer at the border who's going to be looking at your passport, at your visa, at your residency is going to have a lot of discretion. They might look at you and be like, oh, and not really pay attention to how much time you've spent outside the U.S. and say, okay, you can come in, so to speak. But they might also look at it a little bit more closely and be like, you've been outside for way too long. You gave up your right to be here. So to answer your question, Kevin, it just depends. It's very discretionary, and I don't know the specifics of your case, so I'm not going to say yes or no. I'm just going to say you can contact me through Kounsel, or you can contact another licensed immigration attorney to consult on your case to see if there's anything to be done. Going back into waivers, there's different types of waivers, right? Another type of waiver is when you're married to an active or retired U.S. military personnel. There's going to be a waiver available to you where if you're in the U.S. and your spouse is in the military or was in the military, you will not have to leave the U.S. in order to adjust status, regardless of how you came into the U.S. That's the benefit. Confer only onto spouses of military personnel, but it's also highly discretionary, so it's not a guarantee. And also, I want to remind everybody that any petition, any consular processing, any benefit conferred by the U.S. government, by USCIS, by any State Department is not a guarantee of entry or status in the U.S. You're really not 100% in the U.S. until you become a U.S. citizen. Why? Because citizenship is very hard to strip. There's a very limited scope of reasons of why or when people are stripped of the U.S. citizenship. Whereas if you're only a green card holder or you're someone who doesn't have any kind of legal status, there are less protections available to them. A permanent residency can be stripped for certain reasons. Like you can be put into removal proceedings at any time if you're doing things that you're not supposed to be doing. Like, for example, if you go out and commit a major crime, that's going to be a reason for the government to say, you know what, you're a permanent resident. We're gonna start the process of stripping your your permanent residency, and you're going to be put in removal proceedings and sent back to your country of origin. So there is no guarantees until you become a U.S. citizen, and even then, there's always a risk that they're going to try to take your citizenship. But like I said, there's a much narrower and limited scope as to why the government might want to try and strip you of your citizenship, and usually you have to do something like treason or some kind of major terrorism act for them to be like, hey, we're gonna want to strip you of your citizenship. Okay, I have another question. They're asking, can a U.S. citizen sponsor me to study in the U.S.? You're talking about student visas, and student visas are other kinds of visas that don't usually relate to citizenship. The way student visas work is that typically, can they sponsor you? Yes. Petition you? No, not necessarily. Sponsor is different from petition, and so I think I need to know like a little bit what your question is, a little bit more specifically as to what you mean when you say sponsor. So that's the best answer I can give, because I'm not sure I understand the context of your question. So there is that. Typically, though, if the U.S. citizen is an immediate family member, meaning they're your parent, then they can sponsor you regardless of whether you're going to study here or not. Okay, but typically to study in the U.S., you're looking at student visas, and student visas are a different topic that's kind of very specific to education, and so I'm not going to get into that today, just because of time constraints and the different requirements between family immigration and student visas. Okay, so Jay asks, are there any ways where my girlfriend can get permanent citizenship through common law marriage in Texas? Oh, I love this question. This is one of those questions. So here's the thing. So I'm licensed in New York, right? So I can only speak for state law in New York. However, as long as if you're referring to that person as your girlfriend, then that's not your spouse. So you have not established what is called common law marriage. What is a common law marriage? A common law marriage is when you and another person hold yourselves out to be husband and wife without going through the legal process that is obtaining a certificate of marriage, to show that you guys are legally married. I have never done an adjustment of status through common law marriage. And in New York, the law says New York does not recognize common law marriages unless the marriage was established in a state that recognizes common law marriage. Then yes, then it will recognize your common law marriage. So what does that mean? That you had to have held yourself out to be husband and wife in a state that recognizes common law marriage, which means that you can hold yourself out to be the husband or wife of another person in a state that actually recognizes, that says, yes, you can be married without legally being married. So, Jay, it depends. But if you're referring to the person as your girlfriend, then more likely than not, you do not have a common law marriage. And so it depends. I would ask that you contact me on Kounsel to do a very specific consultation, and or contact another licensed attorney that would be able to answer that question. But I'll say this, in New York, this would probably not be considered a common law marriage because you're holding this person out to be your girlfriend, not your wife or your spouse. And so, but I like that question. That is that is one of the questions that I always asked in my immigration classes and in law school. Or not necessarily in class, but I'll always bring it up to my immigration professors. I'll be like, hey, professor, what if it's a common law marriage? Because, you know, not everybody wants to go down to the courthouse and go through the trouble of obtaining a marriage license and doing the thing legally, right? Not everybody wants to get married at church. You know, some people feel like you don't need a paper to be married. You can just say, this is my spouse, and that's it. So I like that question. It's a very interesting question. And it's funny because one of my favorite questions to ask my immigration professors all the time. Maria is asking, my husband is a U.S. citizen. Can he petition my sister or brother? No, Maria, he cannot. U.S. citizens can only petition immediate relatives. Again, a U.S. citizen can only petition his or her parents, his or her children, his or her spouse, or his and her siblings. I'm going to go back to what I was saying at the beginning. There's a very huge misconception about chain migration, that if you're a U.S. citizen, you can petition anybody. That's not true. While you may be able to sponsor just about anybody, depending on their circumstances and depending that you meet certain requirements in a sponsorship affidavit, that does not mean you're able to petition everybody. You will only be able to petition the members of your immediate family. So Maria, no, your husband cannot petition your brother or your sister. However, if you're a U.S. citizen, you will be able to petition your brother and sister. But as I stated earlier in the presentation, petitioning a sibling is something that's going to take a very, very long time. Typically, you're looking at 14 to 16 years. However, if you're from Mexico or the Philippines or specific other countries, you're looking at least 20 years or more. I think for Mexico is 22 or 24 years at least of waiting time between the time you file a petition and the time that person is going to be able to come into the U.S. with their visa. So I hope, I think that's pretty much, well, we have a few more minutes, but I don't know if anybody has any more questions. I hope you guys enjoyed our presentation. I hope to be able to do more of these presentations in the future, and hopefully I answered a lot of your questions. I try to answer all the questions that I was able to see, and hopefully this has informed you a little bit more as to what family-based immigration is and what it's not. And as always, you can contact me on Kounsel or look us up on Facebook. If we can go back to the presentation on the next slide, my law firm is Lopez Galamo Law Group PLLC. You can see on the presentation that my Kounsel link is there. We're open Monday through Friday at 8 a.m. to 5 p.m. Saturdays, 8 a.m. to 1 p.m. by appointment only. We're closed on Sundays, of course, because we all need a day of rest. But we're always open to trying to help as many people as we like. We try to be very, very honest, and sometimes too brutally honest about, what the advantages and disadvantages are for you going forward with your case and whether or not you have a case. We don't take every case. We make no guarantees, but we do the best that we can to help people and to explain the legal reasonings behind why we think what we think. So, feel free to contact me on Kounsel and, do a consultation and a more personal consultation, of course, where you can ask very specific questions and I can be a little bit more specific about my answers. Other than that, that's kind of all I have for today. I don't know if there's any more questions, but I don't see any more questions. So, I have one more question. It says, my wife was a U.S. citizen and passed away while sponsoring me. I think I already answered that question. Where the sponsorship go on? So that's a very specific question. And so I would say that, you can contact me on Kounsel and we can look at your case and kind of see where you're at and what your options are. But even if your sponsorship does not continue through that I-130, there is an application that's very specific to widows of U.S. citizens, but there's a time limit. So it depends on how long it's been since your wife passed away and where you're at and what you did and what you have not done. So that's all I have for that. But like I said, I'm very happy to have spent this past hour with you guys explaining about family immigration, what it is, what it's not. And hopefully you learned a lot. And I hope to be able to do more of these lives. And give you more information. Again, there's one more thing I do want to say, because it's something that happens all the time when people call me. They say, oh, I went to a notario or I went to a notary public and this, and that. Please, a notary public, un notario in the United States is not an attorney and cannot, I repeat, cannot represent you in immigration court. So be very wary of who you're going to. If you choose to hire somebody, please make sure they're a licensed attorney. As you can see, I have my diplomas behind me. This is my law degree and this is my admission certificate to the New York State Bar. So make sure you're hiring a licensed attorney who knows what they're doing. A notary public can seriously mess up your case. I've seen it time and again. I have a client right now who is stuck in their country of origin because they chose to go to a notary because they charge less than an attorney, and he went and now he's stuck because he did not apply for a waiver. So please, be conscious of who you're going to, and just, it's always better to go with an attorney than to go with someone because it's less money and they could maybe mess up your case, and then you're going to end up having to pay an attorney anyway to fix what the other person messed up. So, be careful with that. But other than that, I was really happy to spend this last hour with you guys. I'm happy that I got to talk to you guys about family-based immigration. You have any questions or you want to talk to me some more, contact me on Kounsel. The link is in the comments and, in our presentation. And that's all I have for you today. Thank you so much. And I'll see you hopefully next time.